આપણી પાસે આવી કે તમે જમા કરાવી દે બધાના પાસપોર્ટ. કેરી લાગુ થયો ને? હા સાહેબ. હા, હવે તો ગંભીર ગુનો થઈ ગયો. એ બધાના પાસપોર્ટ અહીંયા જમા કરાવવાનો ઓર્ડર કરી દો. પરમિશન આપી પછી જવું અત્યારે કાંઈ નહીં. સાહેબ અમારો ધંધો સાહેબ એવો છે, ગઈ વખતે સાહેબ ખાલી પોલીસ એફિડેવિટ માટે જ હતું. મેં હવે એફિડેવિટ નથી જોયું હતા. રિન્યુ કરાવવા જોઈશે. રિન્યુ તો સાહેબ કરાવવું જ પડે એવું છે. 2021 થી સાહેબ આમ પાસપોર્ટ એક્સપાયર થઈ ગયેલો. એટલે રિન્યુ તો કરાવો પેલા, પછી માંગ દે. અમારો ધંધો સાહેબ એવો છે કે જોઈ છે ને તો રી જશે. હા સાહેબ, રિન્યુ કરીએ. કેમ નથી આપ્યા? કારણ એવું સાહેબ કે આને અટક 9-10 કરે, 9-10-25 અને મિકી જે મીર રાજેશભાઈ શાહવાળું જજમેન્ટ આવ્યું 6/11 લેખિત જાણ કરવાનું. અટક ક્યારે કર્યા? અટક 9-10. જજમેન્ટ ક્યારે આવ્યું? મિહિર વાળું 6/11-2025. તમારે એનું કઈ કેવું છે? જી સર, મારી રજૂઆત એટલી જ છે કે જજમેન્ટ 6/11-2025 આવ્યું એનાથી એ તો સાહેબ નામદાર સુપ્રીમ કોર્ટે માર્ગદર્શક જે સિદ્ધાંત હતા કે ભાઈ કાયદામાં જોગવાઈ છે તે કાયદાની જોગવાઈનું પાલન કરવું જોઈએ. બીએનએસ જે છે બીએનએસ નું જે 1/7/2024 થી અમલ થયો, એટલે 1/7/2024 થી એનો અમલ થયેલો ને સાહેબ કાયદામાં પ્રોવિઝન છે કે બીએનએસ 47 ને 48 નું પાલન લેખિત અથવા મૌખિક કરવું જોઈએ. પરંતુ સાહેબ તપાસ કરનાર અમલદારે સાહેબ જે પ્રોડક્શન રિપોર્ટ છે એ મેં સાહેબ નામદાર કોર્ટમાં રજૂ કરેલા. પ્રોડક્શન રિપોર્ટમાં બી સાહેબ ક્યાંય એવું લખેલું નથી કે આરોપીને તથા તેના સગાને મૌખિક જાણ કરેલી છે કે લેખિત જાણ કરેલી. હા છે ત્યાં રિમાન્ડ વખતે અને સાહેબ રિમાન્ડ પછી બંને પ્રોડક્શનમાં ક્યાંય સાહેબ ઉલ્લેખ કરેલો નથી સાહેબ. ચાલો ભાઈ, આનો શું જવાબ છે તમારો? જજમેન્ટ તો પછી આવ્યું.
હાજી, એટલે સાહેબ મૌખિક તો સમજ કરેલી.
કાયદામાં મૌખિક છે કે લેખિતમાં છે?
હવે સાહેબ સ્પષ્ટ કહી દીધું છે. કાયદામાં જે સ્ટેચ્યુટ જે છે એમાં જાણ કરવી, કોમ્યુનિકેટેડ કરવી, લેખિત અને મૌખિક નથી.
તો તમે મૌખિક કહી એવું આધારશો?
મૌખિક 47 ના ફોર્મમાં તો છે જ. હવે 48 ના ફોર્મ, 48 નું ફોર્મ તો છે.
ક્યાં 48 નું ફોર્મ તમારું?
નથી મળ્યું?
નથી 48.
અરે 47.
48 બંને નથી.
હા,
એ તો સાહેબ 35 વર્ષની. એ તો અટક 41 જયારે પ્રથમ વારના અટક કર્યા એની જાણ કરી. ત્યારે જ મેં
એ જ 47.
ના નથી
48.
અટક ક્યારે કર્યા છે?
અટક 9-10 કરે છે. અને એમાં કોઈ લક્ષ્મીબેન છે ને, એમને જાણ કરી. એમના ઠાકોર આગેવાન નેતા.
તો એરેસ્ટ મેમો છે ભાઈ.
હા સર,
આમાં ક્યાં લખ્યું છે કે મૌખિક જાણ કરી છે?
લક્ષ્મીબેન ની સહી છે સર.
અરે ભાઈ, તો તમે લક્ષ્મીબેન ને કીધું કે આને અટક કરીએ છીએ. અટકના કારણોની જાણ કરો છે એવું ક્યાં લખ્યું છે? Why are you reading what is not appearing from here? You may protect your officer, but don't misguide.
એટલે મૌખિક સમજ કરી.
But where is
આરોપી
that? Where is that? તમે લેખિતમાં કારણો નથી આપ્યા, પણ લેખિતમાં મૌખિક કીધું એવું તો નોંધ હોય કે નહીં કે ઓન ઇમેજિનેશન we believe your argument to be true. Why are you protecting him?
નહીં સર,
When there is nothing here.
એમને
You
રિપ્લાય
can defend legally, but not what is, don't make the court to read what is not there on it. This is simply a arrest memo.
એરેસ્ટ મેમો અલગ વસ્તુ છે સાહેબ.
તો તમે arrest memo જ વાંચીને કહો છો, બીજું કયું ડોક્યુમેન્ટ વાંચો?
બીજું કોઈ નહીં, એક જ
હા,
ડોક્યુમેન્ટ.
તો આમાં ક્યાં છે બતાવો તમે કે ભાઈ અમે મૌખિક જાણ કરી છે.
પછી એમને આજનો જવાબ આપ્યો એમાં લખેલું છે.
અને
રિપ્લાય
is not a gospel truth.
નહીં, પણ એવું કોઈ પેપર નહીં.
Then you produce the case diary and everything on record.
Yes.
Whether he was informed or not.
આપી દે.
And where is the case paper? We will take that case diary right now only.
આપી દે.
So that other
મંગાવી દે. આપી દે. કેસ પેપર તો અહીંયા છે. કેસ ડાયરી મંગાવી.
and mind well before filing any report.
Sir.
When there is yes, you are.
Yes.
The offence is under section 3162, 319, 3362, 3363, 3364, 338, 340, and 66 and 66 of the IPA. 61 of 61 as well. Sir, the brief facts are only this. I am not named in the FIR.
In cybercrime, who will be named?
The brief facts are only these five. That
But in cybercrime, who will
yes,
name?
sir. Only on the statements I have been. Yes.
What is your role?
Sir, from the records, my role is shown to be that I was handling the account of one Gunjan Sharda, in whose account 4 lakhs have been deposited, and out of those 4 lakhs, 370 has already been withdrawn through self-check. Only allegations are I was handling that account, but there is nothing on record to show that. And he has been granted bail regularly.
He has been granted.
He Gunjan Sharda. He is a
He is a male.
male.
Okay.
he has been granted bail. 3,70,000 was withdrawn through self and 17,000 through ATM. He has been granted bail, and the person on whose statement I have been arrested, he has also been granted bail.
But they were account holders.
I am not an account holder.
They were account holders.
They were account holders, yes. Nothing on record to show that I have appropriated any amount from that account. Mere allegations that I have been handling that account. No proceeds, no trail money in my account. I have annexed the orders as well. So the only allegation is onto this side that I am handling one account. That account holder, Gunjan Sharda, in whose account 4 lakhs have been deposited, out of which 370 has been withdrawn through self. 17,000 has been taken out from ATM. No trail to show that I have taken that money. Only allegation is that I have been handling that account and nothing else. Nothing on record to such any documentary evidence to suggest that I have been handling those accounts.
Why did you handle that account?
Sir, I have no contact with Gunjan Sharda. My name has been revealed by one Vivek. Vivek bhai, Bipu bhai, Vadodari. I have been named by him, sir.
Then where were you till now?
Sir, I filed the anticipatory bail in 2025. Till now, not arrested. On the 18th of February, I was arrested on his statement. And in 2025, the case of the prosecution was that out of those 4 lakhs, 370 I have taken. But there is nothing on record to show that the proceeds of any money have been appropriated in my account, or that I have benefited from that. Nothing on record.
So for 1 year, what you did after rejection of your anticipation?
So nothing.
What you did?
Sir, with respect to this, I have done nothing. That is what my case is. After the rejection of the anticipatory, I have not challenged the order. I have not not filed any anticipatory before the High Court as well. After I was arrested, I filed a bail which was rejected, and therefore I am before your honor. But the orders are also annexed. The person whose account, the person who were named in the FIR, they have already been released.
તમારે આયુ શું કર્યું છે 1 વર્ષ સુધી?
એ સાહેબ ક્રોસિંગમાં ગયેલા, ક્રોસિંગ રદ થઈ 6/3/25 અને 18/2/26 અટક છે.
પણ આ અરજદાર ગયેલા?
હા, ચિરાગ ચિરાગનું ક્રોસિંગમાં ગયેલા
એ મને ખબર નથી. Sir, anticipatory bail, no, not for caution.
Before I
Anticipatory
told also, it was rejected or withdrawn.
Withdrawn.
Then
Sir, I do not have any information with respect to this, therefore have not stated this in this as well. So, but after the arrest I have come. So there is no role. There is no role which suggests that I have benefited from that. Nothing on record to show that.
હવે તમે રિજેક્ટ થઈ પછી શું પગલા લીધા એનું ડિટેલ આપો. રિજેક્ટ થઈ પછી શું પગલા લીધા આની સામે બિલ થયા પછી? જાન્યુઆરી નો આઈનો ઓર્ડર છે, માર્ચ નો હાઈકોર્ટ નો ઓર્ડર છે.
હા, 11 મહિના થયું.
અને હવે ત્રીજા મહિનામાં આવ્યા આપણે લેટ ઓલમોસ્ટ સવા વર્ષ થયા. તમે શું સ્ટેપ લીધા ને પકડવા?
18/2/26 પકડે. 18/2 11 મહિના એને શું કરી દીધું?
હા,
ચોક્કસ.
why? It is suppression on.
Sir, I did not have information, that is why, but I can make that statement on record. Sir, I'll produce that anticipatory bail order as well. I did not have information, sir.
And the suppression will go against you.
Yes, I understand.
So this was the last order I had obtained. My lordship had during the last week, my lord had asked a question as to why earlier I approached the High Court. Actually, the issue was that this LOC is one of the secret document of the government of India, and which is a part of the record of the Bombay High Court Division Bench judgment of 2024, in which a batch of over 40 petitions were heard and disposed of dealing with the LOC issue. And Justice Gautam Patel and Madhav Janwar, who were part of that division bench, they recorded at the beginning of the order itself, saying that getting a copy of the LOC and compendium was very difficult. Some of them were not found, some of them were in the torn condition, so got it transcribed. So this actually publicly the copy of the LOC became available only after this judgment was passed. And in fact, in the judgment also, the Honorable Bombay High Court recorded that the government of India was taking a plea of privilege, saying that it's a privilege document, we will not share even with the court. But nonetheless, after some resistance, they shared it and it became part of that. So when I started searching, my lordship, after a lot of search, I found the judgment, and in that I found this LOC document, in which, if I can take you to my lordship, the LOC document itself, the memorandum which authorizes the issue of LOC, which starts on page number 183, my lordship. It is dated, my lordship, 22nd February 2021. My lord, have it? 183. And I take you to page number 185, my lordship. It records in para number 4, my lordship. The Honorable High Court in its aforesaid judgment dated so and so answered these questions which are introduced below for guidance of the concerned agencies. A. Recourse to LOC can be taken by investigating agency in cognizable offences under IPC or under other penal laws where the accused were deliberately evading arrest or not appearing in trial despite non-bailable warrant and other coercive measures, and there is a likelihood of the accused leaving the country to evade the trial or arrest. I will skip B. I come to subparagraph C. The person against whom LOC is issued must join the investigation by appearing before the IO, or should surrender before the concerned court, or should satisfy the court that LOC was wrongly issued against him. He may also approach the officer who ordered the issuance of LOC and explain that LOC was wrongly issued against him. LOC can be withdrawn by the authority that issued it and can be rescinded. This is very critical, my lordship. Can be rescinded by the trial court where the case is pending or having jurisdiction over the concerned police station on application by the person concerned. Last, the LOC is a coercive measure to make person surrender to the investigating agency or the court of law. The subordinate court's jurisdiction in affirming or cancelling LOC is commensurate with the jurisdiction of cancellation of NBW or affirming NBW. So this is where, my lordship, I have made this application before this court for rescinding the LOC. Now, coming back to this case, which is pending in this court, my lordship, it is common ground that the charge sheet in this case has been filed in way back in 2023. And there is no allegation that I have not appeared before the ED at any time. And if I can take you, my lordship, to page number 10, where I have listed the dates on which I have been traveling in foreign countries right from 2017. It is pertinent to know, my lordship, this case was registered in 2022. Charge sheet was filed in 2023. Whereas I have been traveling since 2017 to various jurisdictions out of India and I have returned every time. Even when I obtained the permission of the Honorable Gujarat High Court, I have complied with all their conditions scrupulously. Apart from that, my lordship, and my travel, duration has been very small, like 2 to 15 days for the business requirement. Now, if I take you to, my lordship, even the Bombay High Court, because the SFI also issued LOC against me, so I approached Bombay High Court also. The last order of the Bombay High Court is at page number 207, my lordship. And on page 8, my lordship, in para number 3, the Honorable High Court, Bombay High Court has recorded the various permissions they have given me from 2024 to 2025 for travel, and I have complied with all their conditions. So I am not a flight risk. Apart from that, my lordship, if I can take you to the judgment of the Telangana High Court, which starts on page number 196, my lordship. My lord, have that, please?
Yes.
Yeah. So, Malachi, I will not read. I will just tell you the gist of this. There was a FIR registered against this person under section 498, 323, and 506. And he appeared before the police, but the date on which the FIR was registered, on the next day, the LOC was issued. He is a person who was working in Dubai, and when he came to know, he filed a writ petition before the Honorable Telangana High Court for quashing the LOC, and the High Court, in this, on page number 197, my lordship, I will read paragraph number 4. Basing on the order passed by this court, the Director General of Police has already issued instruction to all the concerned by circular dated so and so, whereby whenever section 41A CRPC notice is issued, or whenever bail is obtained by the accused, concerned police shall address a letter to the commissioner, and commissioner shall in turn address a letter to immigration office to close the LOC. Next page, my lordship, 198, para 5. It appears that though the section 41 CRPC notice is issued on 1st April 2022, and earlier charge sheet is filed, still the respondent police is continuing without any basis, and this LOC was quashed. Now, finally, what happened, my lordship? After coming to know about the jurisdiction of the trial court in these matters, I filed an application in the special SFI court for resigning the LOC, and which the judgment starts on page number 199, my lordship. It is dated 17 December 2025. My lord, have? May I take you to page number 202, my lordship? Paragraph 8. Ready, my lordship?
Yes.
In view of the foregoing facts and circumstances, it is evident the applicant accused has at all times cooperated with the investigation, has never attempted to evade the process of law. No non-bailable warrant or other coercive process is pending against him. Cognizance in all cases where the applicant's name is accused is yet to be taken, and the trial has not commenced. The material record further demonstrates the applicant has been repeatedly permitted to travel abroad by the Honorable Bombay High Court and has scrupulously complied with all the conditions imposed, returning to India on every occasion. The transaction forming part of the subject matter of the complaint are documentary in nature, and there is no likelihood of the applicant tampering with evidence or influencing the witness. In these circumstances, the continuation of LOC operates as an unreasonable, disproportionate restriction on the applicant's fundamental right to travel abroad. Now I take you to my lordship on page number 204, paragraph 11. Ready?
Yes.
Accordingly, balancing the interest of fair investigation and applicant's right to personal liberty, this court is of the considered view the limited and conditional relief is warranted. The LOC against the applicant accused therefore suspended, kept in abeyance for a period of 2 years from the date of this order, subject to applicant furnishing travel itinerary in advance to the concerned investigating agency and undertaking to appear before the court or the investigating agency as and when required. It is clarified that in the event of any violation of the condition or non-cooperation by the applicant, the respondent shall be at liberty to file an application before this court. In sequel, I pass the order. B, the lookout circular issued against the applicant accused at the behest of the respondent is hereby suspended and kept in abeyance for 2 years from the date of this order. During this period, the applicant accused shall be permitted to travel abroad, subject to condition that he shall furnish complete detail of his proposed itinerary, including dates of departure, return, destination, contact detail, and place of stay abroad to the respondent's SFIO at least 7 days in advance of his travel. So, my lordship, my summary of my submission is that I am not the prime accused. Investigation is complete. So the purpose for continuing the LOC doesn't survive. I have appeared. There is no NBW issued by this honorable court, or there is no complaint by ED that I have not appeared before them whenever they wanted. So my humble submission is that given the business requirement, my lordship, and second, most important is that, my lordship, I am a senior citizen. I have been in business for several years. I have my all property situated in Mumbai. My family is here. All my assets are there. So there is no question of me absconding or using travel abroad to evade the process of law by the ED or for that matter the honorable court. And my travel record itself demonstrates, plus the orders of the honorable Gujarat High Court, Bombay High Court, as well as the SFIO Special Court need to be considered and granted me the relief. Although I have asked my lordship for the quashing the LOC, my lord may consider giving me the same relief as SFIO court in Mumbai of suspending the LOC with the direction that I need to submit my travel itinerary 17 days in advance. So they are aware that for what period I am unavailable if they want to call me for investigation. That is the only submission I have, my lordship.
For the very same judgment, you can go before the IO.
My lordship, yes, but issue is, no, my lordship, now before I have come before this honorable court, now they have filed a reply and they are saying that they will not. See, the problem with the IO is that they want the LOC to continue. As we have seen in case of the Telangana High Court judgment, my lordship, it was a domestic violence case. Still, even after the accused appear, once the LOC is issued, they don't want to withdraw or cancel it. They are saying you are required for the investigation. But
this judgment you can say. Bombay High Court judgment.
My lordship is there, but the issue is that the investigative agency always want to have that control over the accused, whereas they forget that the control is exercised by the honorable court, not by the investigative agency.
But
So
there
issue.
would be a stage just for the very same judgment.
Correct. My lordship, the issue is that because I am appearing, and in fact, the fact that he will not do, the IO will not do it is evident from his reply filed today in this court. It says that my investigation is further continuing and I will not allow you to travel. And it is saying that my application should be rejected. So even if I were to hypothetically make an application, he will reject it summarily, my lordship.
Why do you think of hypothetically?
I'm just saying, my
You
lordship.
can think about the judicial orders that have been passed.
My lordship, I'm saying that even if I were to, given the stand the ED has taken before the honorable court in my application, I have my doubt whether the IO will take that liberty of withdrawing the LOC on its own. Because they are still saying that this LOC application should be rejected.
Yes, they are saying that, but because you came here, therefore they are saying no.
Yeah, my lordship, because the fact is that that normally it is
You
the
want to rely upon the judgment which favor. First, you want to rely the Bombay High Court judgment. Now, Bombay High Court says you can go before the very same authority.
no LOC guideline itself says, my lordship.
So now, after reply, hypothetically you are saying, but before reply, what was your thinking?
My lordship, even before the honorable High Court, the experience has been that even before the High Court, when I was applying for permission to travel on specific dates, they were opposing it. Only the High Court was granting me the relief. So my lordship, now 3 years have passed. See, this their case was registered in 2022. They filed charge sheet in
But after passing
2023.
the order, they have accepted that order. They have not challenged.
No, but that is, my lordship. My lordship, my issue is that.
Permitted.
Correct, sir, my lordship. Every time I have to go, and at that time, as my lordship pointed out, at that time the LOC document itself was not publicly accessible as laid down by the Bombay High Court. After that judgment came out and I found it, I decided to approach the Honorable Trial Court for getting the relief, because the Honorable Trial Court is empowered to even quash the LOC. Because the purpose of LOC, my lordship, is to aid the investigation and ensure that the accused appears. I have appeared before the IO. Even today also, my lordship, my client is appearing before the ED for investigation.
Then you go and say, okay, yes, I want to travel now, permit me to travel.
My lordship, look at their reply. I mean, I don't think they will see. The issue is, my lordship, one thing is there.
You came here, therefore they are opposing. There are steps now. You want to be directly want to jump to the terrace without.
My lordship, my experience has been even
Yes,
before
sir, you might
SFIO,
be.
my lordship, my lordship, before
Yes,
SFIO
please.
also.
Yes, for the purpose of keeping the LC tender, firstly, there was some transaction by the present applicant with the main accused company, AB company, whereby he has received he has a transaction of around 477 crores with the company, in which he retained 63 crores with him. So in my reply, at page number 12.
We are for LOC only.
Yes, sir.
Not on the merit.
Sir, so far as this case is concerned, he has.
Why have you issued LOC?
Sir, firstly, because investigation was going on at the time.
Now, for
There are around 80 crores.
what is I don't know what is this LOC.
Sir,
Now, what is that LOC?
sir,
Why you have you issued LOC?
sir, and initially it was issued because he was found to be involved with the cryptocurrency to the tune of 80 crores, out of which 22 crores were
Why? Okay. I take it there. He is there. He is an accused. He is
Yes.
dealing. Everything is there.
Yes.
That would be a subject matter of other thing.
Yes.
Now, for the purpose of LOC.
For-
Now, when have you issued your LOC?
Trade 28. Even now, sir, he has been summoned by the investigation
And
officer.
if it is not coming, then there is no cooperation.
There is no not cooperation in the investigation. That is why the LOC is required to be retained. Yes, sir. And the judgment of SFIO order that is required, it is clearly distinguishable, because there was observation in the SFIO order that the case in which the LOC was issued, there was no summons issued to the present applicant. However, in which the summons has been issued and complaint has been filed, LOC has not been issued. So for that, the SFIO court has suspended the LOC. But in this case, he has been accused in the present case, and further investigation is going on, whereby he has not been cooperating and appearing before the investigation officer.
So he has not appeared before you.
Yes.
My lordship, I have, where in his reply also, he
At
doesn't
page
say.
number 12 of my reply, of category stated in para 5.6. He was summoned to appear on 24th of February, but he did not turn up.
That is only one instance, my lordship, in last 3 years. And the reason he has also replied, and he has made himself available today as per the convenience of the IO, my lordship. He is there before the ED today.
Is it there?
Yes.
Yes,
He's there. He can check, he's
Yes,
there
sir.
already.
Today, he
So
has-
it was just a
He was
question
called
of,
today?
Huh?
He was called today.
Yeah, no, he was called last week when I came here. So he was under the, because he wanted to travel urgently, he was under the impression that he may get the relief from this honorable court. So he wrote to the IO saying that I am applied for this, let me travel and come back and I'll appear. But since my lordship kept this, matter today, so he has already,
It would be considered as a very smart play.
my lordship, but,
By filing this application, you avoid the summons. How it can be?
my lordship, no,
Yes, yes.
my lordship,
Yes, yes.
may
No.
make submission.
Will not consider.
My lordship, may. Kindly consider,
You want to
And
direct.
on the very same day, they have preferred an application on board.
my lordship, kindly
Get
consider.
their exemption, you use this tool.
No, my lord, I cannot travel. See, issue is, my lordship, unless I get this honorable court's permission, I cannot travel because
Then
LOC is.
first you appear before him
Yeah, I am appearing today, my lordship.
today, no?
Yes.
Yes.
So, my lordship, the
So
issue
today,
was,
if you are appearing, then it is a summons under section 50.
my lordship, may I make
You
submission?
want to indirectly get relief of ignoring that summons by filing this appeal.
No, my lordship. One second, may I make submission? See, if and from
Whether
2022,
you had given today's date,
Sir, I'll check from Jayo. It was given for 24th. Now, might be they have appeared on their own.
no. I'm
Or-
not. No, you can
I'll
check, but
check
my
it from my manager.
client has
you have received summons for today?
yes, that is what I'm saying.
Where is
So I don't have a copy because he was traveling, so he's
I'll
on the
verify
way.
it from
My lordship, I'll tell you what he has explained to me, that he has
You don't
offered
want
3
this
dates.
explanation.
No, I'm saying that, my lordship, he offered 3 dates and the IO has selected today's date for appearance. So he is appearing before, right now he is before the IO, my lordship. He can check and confirm to this court. I'm not lying.
That he is before guy, but for someone, they have made a request or not. That summons has not been issued. I'll just verify it from.
But then check whether your IO has given this today's
Yes,
date or not.
yes.
I'll
If you don't cooperate, then there is out.
No, I agree with you, my lordship. I'm not denying it. And secondly, my lordship may also consider that after 2023, today is the last week was the only first time he was summoned again. So it is not that he has been summoned and he has not appeared. So question is that there was a long hiatus between last time when the summons was issued, he appeared. He provided
Then
all the
you-
document.
You file your reply against his, whether they are lying or they are saying the correct facts.
I can, my lordship may, I'm making oral submission. Do I need to file reply? Whatever my lordship consider appropriate, I'll do it.
You would be better
Fine.
to take a decision whether your oral submission is to be considered or if they,
Fine, I can find the written submission. my
if you want it, that is not.
No, I get your point, my lordship. It will be on the record. So it is a question of, and as I said, my client has categorically told me that after last week, he, made a request giving 3 alternate dates. That was Thursday, Friday, and Monday. The IO has said that you come on Monday. So today he is appearing before the IO. And for so many years, my lordship, I think he is also making allegation about the one.
They have also not denied that.
Yeah, that is what I'm saying. So only one instance, because he was under the impression that he wanted to get the relief, he may get that. So he said that I will appear after I have traveled by. So he has not said that I will not appear. He just sought the day and.
But let him then, we will test him also. Whether
Fine,
he is
my lordship.
withdrawing or not withdrawing LOC. If you are cooperating, then he would be abiding by that decision.
My lordship, based on the record which are available with all the judiciary, even Telangana High Court, its record, my lordship may recall, it says that Commissioner of Police has issued a standard direction saying that once he issues 41 CRPC notice or bail is granted or the accused appears, please cancel the LOC. They don't do it. See, problem is that they are worried. My assessment is that they are worried that if they do it suo moto, then somebody may make an allegation against them. So that's why they prefer that somebody comes to the court and the court passes the order, then they can say fine. So that is the issue, my lordship.
Now we want to change that mentality also.
My lordship may whatever.
If they are having one remedy, then let everyone go before their remedy. Let them say yes, no, we will deny it.
My lord, if my lord permit, I'll just make one mention about SFIO, what happened. Even after this, they said that we will not allow. I have to go back to the court and say that they are saying that we will not allow you to travel. That is the
Then
problem.
you consider it because everything not on the shoulder of the courts.
I agree, my lordship.
But you also do not want to go there. He also do not want to consider.
No,
Now
because-
both of you want that.
No, my lordship, my based on my experience, because in the High Court also they consistently opposed mine. Even when I'm asking for travel on specific dates, they were opposing it.
They will oppose.
That is the reason I'm saying. And my lordship,
So
the LOC.
they are investigating agency. They would have their own concerns.
My lordship, I'm saying that the genesis, the document from which they derive the authority itself says that the purpose of LOC gets extinguished once the charge sheet is filed, once the accused appears, then it is the end of the event. It is, and for my lordship, the jurisdiction has been conferred in my lord's court because it says it is equivalent to NBW confirmation or cancellation. So that is the reason I have appeared before this court, my lordship.
That we will consider. We just verify everything second hand.
Okay. my client replied to him saying that he had some issue, so which replies on page number 9, my lordship, and he requested that if he can come and meet on 3rd of March. On page 8, my lordship, there is an email from the EDIO saying that yes, he can come on 3rd March, 11 a.m. And my lordship, the last page is my client's receipt for his entry into the ED office today. So, my submission, my lordship, is that as far as the cooperation with ED is concerned, so after 2022 July, there was no summon. This was the first time after 3 years I was summoned. So I requested a date which he agreed and he was kind enough to exceed. And I appeared today before the ED. So the issue that I have not cooperated is not correct. And if I can take you through some of the points which are emerging out of the reply by the ED, my lordship. Now, as far as the ED's reply is concerned, on a lot of pages, I mean, all the way up to page number 5. This is the background of the case. I mean, CBI registering the FIR and then ED registering ECIR on that basis, etc. Those background is given. I'm on page 6 and 7, my lordship. This is the table which is given, alleging that I received 477 crore and I transferred back 414 crore. And on page 8, my lordship, 1, 2, 3, paragraph number 4 on page 7, it alleges that I received 63.12 crore benefit. So, and these are all part of charge sheet, my lordship. There is nothing new in this. And on page 11, my lordship, in paragraph number 5.3, if you see 9th line, my lordship, which starts with eventually caused a loss of 22,842 crore. So there is an allegation against ABG Shipyard of causing a huge loss, and allegation against me is that I have received a benefit of 63 crore, my lordship. And as far as my contention in my application, my lordship, in paragraph 11, page number 3 of my application, my lordship. In that I have submitted that I have cooperated with ED from March 2022 to July 2022, and I attached a copy of that summons, my lordship, in the rejoinder. And after that, I was never summoned. And this is the after 3 years, after 4 years rather, in February 2026, I am summoned and I appeared today. So there is no issue of non-cooperation as far as my participating in the investigation and providing information or document is concerned.
The reason bench order of the Bombay High Court. 207.
Page 207 on the no, which one are you talking about? In my thing or that other one which you are talking about,
Other-
LOC related?
LOC.
That I am not, I'll take a print out. Because the, it's a 398 page judgment, my lordship.
You can give the number.
No, I have it, I will get it printed right now.
No, I will get it. You can give the number. I will get it in the soft copy. Number and a name and a date of the.
Okay, citation I will give, my lordship. In my lordship, for me, I will just read two paragraphs which I earlier cited.
Just give the, I will have to go through.
Fine, fine.
So far as jurisdiction.
I will. In,
What you have to say about your,
yes, sir.
with regard to legal position and, that you have to keep on reviewing your LOC.
Yes, sir. But as to present situation.
Now, what have you done for this, years? That is not coming out from your report. So whether you have reviewed why you want to continue, because unless you discontinue or continue, even, as per the guidelines which I have, you will have to,
That is because presently at this level, the investigation was required to be carried out for this present applicant because some rupees of crimes to the tune of around 50 crores was pending to be identified.
Hmm.
So he was summoned on the given date of 20, so we are on 24th. In if your honor, you see the page number, last of page number 2 that I have kept the email relevant details. Last of page 22,
That we have
page
seen.
30. Email I just kept it first possible.
that we are not concerned. You tell me say, why you have, when the LOC was issued?
Yes, sir.
So how,
It is required at this sector only because the investigation is going on. Once it is done, so then certainly the review would be done. But presently is non-cooperation at the date of 24 is required to be.
until 24 now is before
Sir,
you
now-
today.
If
he has,
statement is being recorded, sir.
Even if he has not cooperated, then also he has written a mail to you.
Yes, sir. That mail is also to be taken on 21st. He writes to IO that I have already moved the special PMLA report, whereas no such application was pending as on date. Then, sir, on 24th, he does not turn up before the IO, and on 26th, he sent an email. Since the matter has been kept on third by this honorable court, I made it given a date on the court third. So now his statement is being recorded as present in the for the IO. And possibly he would be required to be summoned again because there are some certain documents which are sought from him. So his presence again would be required. But it won't be concluded as of per the inspection of the IO. The statement would be recorded for 1 more or 2 more days.
With your permission, I make one submission regarding this submission to this court. If you see the, actually this application was ready and on 16th.
We will not go by the technicality.
No, I'm just making one small submission, my lordship, on the issue that I came here 24th and 24th, he did not appear, that is not correct because I signed the
I am
application.
not going into those technicalities. Why, what again, that?
No, my one line submission was that, my lordship, my application was there, but court was not in session.
He will direct to cooperate in the investigation and once it is done, certainly review would be done for the LOC. But at present, we are determining and identifying the procedure of crime. It is around 60 crores, which is yet to be determined.
So you can, record his statement.
So if the statement is being recorded.
Yes, you can keep on investigation.
That is.
Whether any review was done by you? When was the first poll by you? At first point of
In
time?
22.
22. So now we are in 26.
In 20.
So we can. Okay.
So let the, I completed the investigation for this time. Thereafter, certainly you can be carried out.
Wait for some time then.
My only, one suggestion would be to revert to that.
We can, yes, sir.
Fine. Whatever my lord passed in the order will be always subject to my cooperating investigating agency. I mean, I can't.
Subject to that order has been passed, then that condition is there.
Correct,
Otherwise-
whatever. If-
Otherwise,
see,
it is,
No, my
it
lord,
can
my
be,
thing-
otherwise, either of the parties have the remedy.
my submission to my lordship, even if my lordship grant me the permission or the relief, it will be always subject to cooperation with the investigation which is there in the SFI report by Bombay also. Of like,
We will not go by the Bombay.
Landlord of the subject properties is similar, your lordship, and this both the suit.
There are only similar parties.
Yes, sir. Similar party, the landlord is similar, lordship, in the both the matter. And the issue, the prayer, the fact of the both the suit is similar.
RPS 240 is filed by Rashid Bhai.
Rashid Bhai Wala.
So your client.
Yes, your lordship. In the both the suit, 204 and 241, in both the suit, I am appear on behalf of the petitioner, your lordship.
And 241 is filed by you.
Yes, your lordship. It was filed by someone else. Subsequently, I'll.
The part in person કોણ હાજર છે?
નીતિનભાઈ હાલ છે, સંકેતભાઈ નીતિનભાઈ બહાર હતા
હવે
અત્યારે.
RCS 240 શેનો છે?
Sir, it is for the. Sir, what has happened? આમાં સાહેબ
દાવો શેનો છે એ કે ને મારા ભાઈ.
દાવો એ જ છે સાહેબ કે આમાં ટેનન્ટ હતા 1991 થી. સબસિક્વન્ટલી એના જે
હવે તે દાવાનો વિષય વસ્તુ કોર્ટમાં કેમ સ્ટોરી તો ઈ સાંભળશે નીચેની કોર્ટ.
નહીં સાહેબ એ જ તે કે અમને ડિસ્પોઝેસ ના કરે પ્રોપર્ટી માંથી.
એટલે ડિસ્પોઝેસ ન કરે એનો દાવો છે.
યસ યસ છે.
પછી RCS 241
સેમ સાહેબ બંનેની પ્રેયર ફેક્ટ બધું સેમ જ છે બંને.
એમાં ડિસ્પોઝેસ નહીં કરવાનો દાવો.
યસ યસ
કેમ બે દાવા દાખલ કર્યા તો?
આ બંનેના જે ટેનન્ટ છે અલગ અલગ છે. કેમ કે સાહેબ સબ્જેક્ટ પ્રોપર્ટી બંને
આ રસિકભાઈ માલિક છે કે ભાડુઆત છે?
ભાડુઆત છે સાહેબ.
ભાડુઆત છે.
યસ યસ.
તો બે દાવામાં તમે જ ભાડુઆત થયા ને?
યસ યસ.
તો બે દાવા હું કામ કર્યા?
પણ સાહેબ બંનેની સબ્જેક્ટ પ્રોપર્ટી બાજુની શોપ છે સાહેબ. આજુબાજુમાં ઘણી બધી શોપ છે. આખી પ્રોપર્ટી એમને આમાં સાહેબ કેવું હતું કે 1991 થી
એટલે ભાઈ ઈ માન નથી સાંભળવું.
સાહેબ શોર્ટમાં આપ સાહેબ ને પેલા માટે કેમ 2016 સુધી સાહેબ બરોબર ચાલતું હતું. સબસિક્વન્ટલી 16 માં
અરે ભાઈ બધું નીચે સમજાવજો. તો બે દાવા હું કામ કર્યા ડિસ્પોઝેશન ના? ઈ તારી દુકાન કેટલી છે તમારી?
બે દુકાનો સાહેબ અલગ અલગ.
એટલે બે દુકાનના બે દાવા કર્યા.
હા એક મતલબ એ રીતે બંને અલગ અલગ.
એક જેડી માં કેમ ગયો ને એક SD માં કેમ દાખલ કર્યો ઈ કયો?
સાહેબ that is the subject to the registry હવે સાહેબ એ.
અરે ભાઈ રજિસ્ટ્રી તમે લઈને ગયા છો ને પેલા દાખલ કરવા. તમે જેડી માં દાખલ કર્યો છે એટલે જેડી માં ગયો હશે. બાકી નંબર એક જ છે બે.
that I have to then verify છે.
પ્રોબ્લેમ તો ન ગયો હોય જે જુનિયર ડિવિઝનમાં કે સિનિયર ડિવિઝનમાં ક્યાં દાવાની કોપી રજૂ કરી છે?
હા સાહેબ, મારી ટ્રાન્સફર એપ્લિકેશન ની સાથે જ છે.
તમે એક દાવો દાખલ કર્યો અમદાવાદમાં મહેરબાન સિટી સિવિલ જજ સાહેબની કોર્ટમાં. બસો એકતાલીસમાં તમે ક્યાં વાદી છો મારા ભાઈ? વાદી તો રાજેશભાઈ સોમાભાઈ છે.
No, no, sir. Rajeshbhai is the plaintiff. I am appealing on behalf of Rajeshbhai. That is what the subject is.
એટલે તમે હમણાં કીધું કે રસિકભાઈ તરફે એફઆઈઆર થાવ હો તમે.
હા, આ મેટરમાં રસિકભાઈ તરફથી 240 જે સૂટ છે એમાં રસિકભાઈ તરફે, 41 માં રાજેશભાઈ તરફે. બંને સૂટમાં હું
તમને હમણાં પૂછ્યું તો એમ કહો કે બેયમાં વાદી ઈ છે. બે દાવા તમે દાખલ કર્યા એવું કહો છો ને તમે.
હા, દાવા બંનેનો એટલે બંને જે વાદી છે આમ અલગ અલગ છે પણ બંનેના વતી અપિયર હું કહું છું. 240 રસિકભાઈ દાખલ કરેલો છે, 41 રાજેશભાઈ દાખલ કરેલો છે અગેન્સ્ટ ધી સેમ રિસ્પોન્ડર.
બરાબર.
વિથ ધી સેમ
વકીલ તમે સેમ છો એમ.
યસ યસ.
તો હવે તમે સમજાવો કે તમે એક ત્યાં દાખલ કર્યું ને અહીંયા કેમ કર્યું? પેલા તમે કરો ને હવે આ બેમાં સ્ટેજ શું છે?
Sir, so far as 240 is concerned, it is on the chief examination of plaintiff and plaintiff's evidence, and 241 is for the hearing on exhibit 5. So both are on initial stage.
બેમાં ઓર્ડર થયો છે કે એમાં?
Sorry, sir.
બેમાં એક ઓર્ડર થયો છે?
Ah, sir. So far as 240 is concerned, in which exhibit 5 was rejected, subsequently we went in appeal. That appeal was also dismissed, and subsequently we went to the High Court. Now the SC is pending before the High Court. High Court, why its order dated 25th of August, why this oral order dated, if my lords can find on page 3, High Court has directed the respondent herein also to not dispossess us from the property without following due process of law. So that after, so far as my limited knowledge concerned, if after that order, the respondent herein has a file one another suit for the eviction from us to the property.
એ ક્યાં? ઈ ક્યાં છે?
એટલે
એ દાવો દાખલ કર્યો ને?
as per my limited knowledge, it was
એટલે આપણે લિમિટેડ કે અનલિમિટેડ ખબર
But સાહેબ-
પડી કર્યો છે
એટલે સાહેબ એમાં એવું હતું કે એમને ઘણી બધી લેન્ડ ગ્રેબિંગ પ્રોસેસ ઇનિશિયેટ કરેલી છે, એમાં ઓપીઆર
તો પછી તમે ઈ લઈને આવશો કે ભાઈ આ દાખલ કર્યો હવે આને એવા લઈ જાઓ.
સાહેબ એમાં મને ઇન્સ્ટ્રક્શન નથી, આઈ એમ નોટ અપીરિંગ ધેટ મેટર ઓનલી. કેમ કે સાહેબ મને આ ખબર પડી એ લેન્ડ ગ્રેબિંગ માં અપીયર થયો તો ત્યાં એમને મને ઓરલ ઇન્સ્ટ્રક્શન કર્યું કે અમે એવિક્સેશન ફાઇલ કરેલો છે એઝ પર ધી હાઈકોર્ટ ડાયરેક્શન.
પેલા જ મને એ સમજાવો કે આ બે પક્ષકાર દાવા જુદી જુદી રીતે કેમ દાખલ કર્યા? નંબર તો બે આગળ પાછળના જ છે, 240 241.
એ બંનેનું ફર્સ્ટ ટાઇટલ પણ
એક જેડી માં ગયો ને એક એસસી માં ગયો. તમે કોર્ટને કીધું નહીં કે આ આવું કેમ કરવો તમે? બે નથી ને હાઈકોર્ટ નો કઈ
ના સર સાહેબ એનો ઓર્ડર મેં લગાવેલો છે આપ સાહેબ પેજ પર 1 after the list હાઈકોર્ટ નો સાહેબ ઓરલ ઓર્ડર હતો કે રિસ્પોન્ડન્ટ હિયરિંગ આર ડાયરેક્ટેડ નોટ ટુ ડિસ્પોઝેસ ધી પિટિશનર વિધાઉટ ફોલોઇંગ ડ્યુ પ્રોસેસ ઓફ લો.
હા તો ભલે તો દરેક પક્ષ તમે ભાડુઆત તો જુદા જુદા છો ને
Yes, your lordship.
હા તો એમાં શું જરૂર છે
But the lordship, if the both the suit will hurt
એમાં ક્યાં
together, then
પક્ષ દરેક ભાડુઆત જુદા છે તો તમે ખુદી પોતપોતાની જે વિચાર કરજો પુરાવા આવે તમારો કોમન પુરાવો ક્યાં છે એમાં?
common pro sir એમાં
બે પક્ષકાર જુદા છે એના માલિક આ છે એક જીતે ને આવે તો ફરક શું પડે એમાં?
અલ્ટિમેટલી આજુબાજુની બંને દુકાનો છે શોપ
એ
છે
તો આજુબાજુ તમે ખોટો કરાર કર્યો ઓલા સાચો ભાડુઆત છે
and then leave it up to my lord. My written argument is that may consider as my oral argument an appropriate order to pass. And your lordship, I am relying upon what Supreme Court has said. Oblige, your lord.
વસ્તુ ચાલીસ ની અંદર એગ્રીકલ્ચરની 4 ગામ મંજૂર થઈ છે 8-5 ગામ મંજૂર છે 8-5 ગામ મંજૂર થયા પછી અહીંયા બીજી કોર્ટમાં મેં સાંભળી લીધું પછી હાઈકોર્ટમાં ગઈએ સાંભળી લીધું પછી તો સાહેબ આપ જે હુકમ કરો એ એવું નહીં પણ તમને વાંધો શું છે આમાં એક કોર્ટમાં ટ્રાન્સફર થાય છે એમાં સર 241 શર્મા સાહેબમાં જે છે એમાં અત્યારે હાઈકોર્ટના ઓર્ડર પ્રમાણે મેં ઇલેક્શન દાખલ કરી છે 295/2025 240 એ કઈ કોર્ટમાં છે એ ચોપડા સાહેબમાં છે અને બીજી હમણાં દાખલ કરી 63/2026 એ શર્મા સાહેબમાં હવે જે બધા જે નવું ઇલેક્શન શું દાખલ કરી 295/2025 એમાં 2-3 મુદતો પડી ગઈ કોર્ટ કમિશનથી થઈ ગયું અને નેક્સ્ટ 20 તારીખની અને શર્મા સાહેબના અંદર 63/2025 થી જે ઇલેક્શન દાખલ કરી એની છેક એપ્રિલની મુદત પડી એટલે કેસ લંબાવવાની અને કેસ ખેંચવાની ટાઈમ બગાડવાનું કારણથી આ થયેલું છે જે કેસ જે જગ્યાએ ચાલે જે જગ્યાએ ચાલવાનો અને કાં તો 240 ટ્રાન્સફર થાય એ લોકોએ 241 ટ્રાન્સફર કરવાની છે એની જગ્યાએ અમે 240 ટ્રાન્સફર કરવાની અને કદાચ ના થાય તો એ કન્ડિશન માટે જે જગ્યાએ ચાલે એ જગ્યાએ ચાલે 240 કામ ટ્રાન્સફર કરવું એટલે એ લોકો 240 ચોપડા સાહેબ એ સ્પીડમાં ચાલે છે નહીં થાય અને ત્યાં ટ્રાન્સફર કરી દે ચોપરા સાઈડમાં. તમારું કેવું?
અને જે તો એ જ છે સાહેબ, ચોપડા સાહેબ નું જે કે છે સબઓર્ડિનેટ કોડ છે. મારી રિક્વેસ્ટ એટલી જ છે સાહેબ ને કે that from subordinate
પણ
code
ભાઈ સબઓર્ડિનેટ કે હાયર કોર્ટ એ તો એની પેલા ઉપરથી નક્કી થાય ને. એસડી છે એ તો જેડી દાવો ચલાવી લે છે. એટલે તો હું પૂછતો હતો કે ભાઈ તમે દાવો એક એસડી માં એક જેડી માં કઈ રીતે લ્યો?
વેરીફાઈ કેમ કે સાહેબ બંનેના પોસ્ટ ટાઇટલ મેચ લખેલું છે કે મહેનતમાં સિટી સિવિલ સાયન્સ ની પોસ્ટ.
આપણે પેલા એ વર્કઆઉટ કરો કે ભાઈ તમારો જ્યુરિસ્ડિક્શન નો ઇસ્યુ હોય તો બરાબર છે, પિક્યુલરી જ્યુરિસ્ડિક્શન નો ઇસ્યુ છે તો બરાબર છે.
જ્યુરિસ્ડિક્શન નો તો ઇસ્યુ છે કે શોપ બંને બાજુની શોપ છે. જ્યુરિસ્ડિક્શન નો તો
જ્યુરિસ્ડિક્શન કેટલા હોય? ટેરિટોરિયલ હોય. બીજું કેવું હોય? પિક્યુનરી. હા, એટલે પિક્યુનરી જ્યુરિસ્ડિક્શન છે કે નહીં તો જોવું પડે ને. બેનું પિક્યુનરી જ્યુરિસ્ડિક્શન જેડીને લાગુ પડતું હોય તો પછી જેડીમાં જાય તો શું વાંધો? બે વેરીફાઈ કરો, બેમાં વેલ્યુએશન કંઈક કરી હશે તો એસડી જેડી નો પ્રશ્ન આવે. તમે બે કયો એવું કઈ નહીં થાય હો. તમે કયો 240 મોકલો, ના કે 241 મોકલો. જવાબ જોઈ લીધું. વાત તો હજી પ્રોપર્ટી તો એક જ છે ને, માલિક એક જ છે. તો ભાઈ તમે ઓનર છો, તમારી અમે બે જણે દાવો કર્યો છે, એક જ બાબતથી લઈને કર્યો છે ને. હા, તો એ એક કોર્ટમાં ડિસાઈડ થાય તો વધારે સારું નહીં? આપણે કોર્ટમાં જઈને રજૂઆત કરજો, જે કોર્ટમાં બધી કોર્ટમાં એક જગ્યાએ જાય છે. દાવા જ ખાલી એક કોર્ટમાં જાય છે, એ ભેગા નથી થતા. પછી બી કોર્ટ નક્કી કરશે. બે માંથી ત્રીજા મોકલી દીધો બધા કેસ તમારે.
I don't have any objection if my lord.
બે મહિના રાહ જો, બે પ્રશ્નો પૂરી થઈ જાય તમારે.